couple chambers and a couple individuals joining us.
So today, I am pleased to welcome Davis Brown Law Firm here today. So Matthew is in charge of kind of patents and intellectual property, and then Kelsey Cross is actually going to cover the employment side of this. So we're kind of tag teaming with two attorneys, and I'm going to hand it off to them and let them do their own little intros today.
Great. Thank you, Christina. Hello, everyone. It's a pleasure to be here with you all today. Again, my name is Kelsey Cross. I'm an attorney at the Davis Brown Law Firm, and I focus primarily in the areas of employment law and litigation. So what that means is I advise businesses and employers on how to comply with state, federal, and local laws, and then I defend them when they get sued or when they want to proceed with a lawsuit to protect their business. So throughout this presentation today, I'm going to approach it from that background and that angle. Matt and I, he'll speak to his specialty. We routinely work together because a lot of our clients and the businesses we work for need both of our expertises. So that's why we're here today.
All right, I got my own.
Oh,
Sorry. Yeah, so as Kelsey said, my name is Matt Warner Blankenship. I'm a patent attorney at Davis Brown. I've been there about 7 years. When we were originally asked to give this talk, I started looking at it and thinking about it, and it seemed to me that as a patent attorney, most of what I do involves helping people secure intellectual property rights, so patents, trademarks, copyrights, whatever it is. But we needed to, it seemed to me that a lot of the problems that faced by businesses these days relate to issues with employees as well, and that protection involves kind of Kelsey's end of things, so we thought, it made sense to do it together.
So I do want to spend a moment here. Let's see. There we go.
There you go.
On our disclaimer. I don't know if this pertains as much to Matt's world. It might, but certainly in my world of employment, it's very fact specific, and a lot of the advice we give can change on a single fact. And so that makes it very complicated for you guys and for us. So we're going to try to hit the high points of some advice in how to protect your intellectual property and your business when employees come and go. But please keep in mind, these are really red flags and generic general advice. It's no substitute for your own independent legal advice. I imagine it's the same thing for IP?
Yep.
Okay, great. So keep that in mind. And
I took it.
Okay.
Totally stole it from me.
So I also want to point out that we are hoping that this presentation will be conversational. We don't want to talk at you, we want to talk with you. So we invite questions at any time throughout this presentation. If you have any questions, just raise your hand or shout out the question and we'll try to speak to it. Same thing with those tuning in via the webinar. We have a way for you to get your questions to us, so please ask any questions at any time. All right, so we are going to talk about the 5 ways you can protect your business in regard to intellectual property and protecting your business interests when employees come and go. So we're going to, the first 3 areas of this presentation are focused on intellectual property and steps you can take to protect that area of your business. And then I'll end the presentation talking about some of the employment aspects and ways you can protect your business outside of intellectual property, which of course they go hand in hand.
Okay, I think I start here. So one thing that I wanted to mention just kind of briefly, this isn't really a talk about securing intellectual property per se, it's more of a talk in terms of dealing with the Patent and Trademark Office, but it is important to kind of cover what we really mean when we're talking about intellectual property. There are 4 kind of canonical IP rights that we talk about when most people think about it, what IP means. Patents, trade secrets, trademarks, and copyrights. And each one of those 4 different things, 4 different areas, protects sort of different aspects of what a business might want to protect about ideas and content that they generate. Patents are kind of the classic example. They protect your ideas, so any process that you might have, any product that you have, devices, machines, things of that nature sort of fall into the patent scope. patents don't last forever. They last for some period of time, but it's not indefinite. And so part of the bargain, and this is important to be kind of aware of when you're thinking about what your intellectual property strategy is going to be, is that patents, end. Trade secrets, however, can last indefinitely until they're actually revealed. So, the formula for Coca-Cola is still considered a trade secret, and it's been, that's been the case for, time immemorial. So again, trade secrets protect confidential information, and this can be things along the lines of patents, so products, so certain kinds of processes in particular, and then things like customer lists, marketing plans, other things that are sort of business intelligence that you may have inside your company that you may not want to let out for whatever reason because it could be valuable to a competitor. All of those kinds of things can kind of fall under the broad definition of trade secrets. Trade secrets are sort of different than the other categories here in that there are less formal procedures for securing them. You don't reach out to the patent office. There's no trade secret office that sort of says that's a bona fide trade secret. You just have to keep everything really close to the vest, and the best way to do that is through a combination of internal procedures and the way in which you deal with your employees and sort of just keeping it secret around the business. Trademarks actually relate to the brand themselves. So Apple is a good example. Trademarks are something that are refer specifically to the company in almost all cases, or the product itself, and not the people behind it or the way in which it's made or anything like that. So in a lot of ways, trademarks are fairly straightforward for companies to protect as long as you're going out and using it as in association with your business, you get some protection over that. Then we've got copyrights, which relate to the expression of ideas. So what that means traditionally is things like books, music, works of art, movies, things like that. But it also can apply to software. And it's important when thinking about, if your business has software that they've developed that's proprietary, you might want to think about whether or not it makes sense to try and go after a patent on that software, or to try and protect it through sort of copyright schemes or other methods of keeping it or other methods of sort of keeping it back behind the book so nobody can actually see what it is. The thing to know really about software is that the patent system is pretty pessimistic about software, so getting patents over software is pretty difficult, and the patent system also takes a long time, and software tends to move pretty fast. So that's just kind of the 5-minute overview of exactly what we're talking about. Go ahead.
Does the trademark have to be registered? If I make a sign that looks like something and someone copies the look, is that an infringement, or does it have to be registered?
That's a great question. No, it does not have to be registered.
Matt, I'm going to interrupt here, and for the sake of those tuning in via the webinar, I'm going to repeat the question.
Oh, sorry.
And I think your question was, does the trademark have to be registered? And so that's the question, Matt. How would you answer that?
That's correct. The short answer to that is no. I mean, of course, it depends on the exact circumstances. But as soon as your business is out using a mark in commerce, you get common law protections under that. So there are all sorts of state laws that will allow you to pursue a competitor. Now, the scope of that is questionable. If it's someone in Maine and you're doing it here in Des Moines, you may not have any recourse against them because you don't have federal protection. You can reach out to the trademark office. You can actually apply for a federal trademark registration with the trademark office, which gives you broad nationwide priority over the mark. But that's a good question. Go ahead.
What about copyrights? Do they have to be applied for?
They do have to be applied for, although it is not as stringent as the requirement for that patents be applied for. With a patent, if you come up with an invention, as soon as you disclose it, the clock starts ticking, and you have to apply for it with the patent office in order to get patent protection. With copyrights, it technically attaches from the moment of creation, so as soon as I draw a doodle, that's copyrighted. I can pursue someone else for copying that doodle that I drew without actually having to have registered it at the time that I did it. Now, registration early provides certain statutory benefits to you, so it makes it easier as a plaintiff to go after someone if you've registered it early on in the process. But you don't have to do that until, if you copy my doodle and I want to go after you and it's 3 years later, I can go ahead and register the copyright and then go after you in court over that.
So for those tuning in, the question was, do you have to register copyrights?
Third time, I'll get this right.
And so it sounds like you don't have to register copyrights, but you can.
Yeah, you can. And it's pretty straightforward as a process. I think one of the things to consider, and one of the things that I want to stress, is that when you think you have something that is protectable IP, you should make steps to lock it down as soon as possible. There are benefits in all three, in these three statutory cases. There are benefits to going and applying at the Patent Office, applying at the Trademark Office, or applying at the Library of Congress early on when you got something. And with these two, in particular, with trademarks and copyrights, the process is not as expensive as you might think it is. Patents, I wouldn't be remiss if I told anybody that a patent's cheap. But the filing fees for copyrights and trademarks are really quite reasonable and worth doing early on. Because it takes, as you might guess, it takes the Trademark Office and the Copyright Office some time to actually process and approve your application. Good questions. Anybody else?
I'm going to jump in here with some employment advice regarding registering trademarks and copyrights. I'll talk about some of the contracts you might have with your employees later on in this presentation. And if those get litigated and there's an issue about whether we can enforce those agreements, one of the factors that a court might consider is what steps have you as an employer or a business taken to secure the information you now are concerned about being released. So if you have taken steps along the lines here of what Matt just talked about, that can be used, if we're trying to argue, we need this protection court, and here's examples of what we've done to try to protect, our business information.
Good point. So, I guess part of what I wanted to stress here was that in addition to these being kind of the traditional categories of IP rights, one of the best things that you can do to protect yourself and your IP, your business's IP, is to go and talk to someone early about securing those rights once you've identified them. Any steps that you take early on in the process will definitely save you pain in the long run. To that end, part of what we're talking about here is the relationship with employees. And one of the first things that you can do, so our number one on our list, is putting together assignment agreements that convey IP rights to the employer upon creation. So this can kind of happen in two general ways, and we'll talk about that. At first, I want to talk about what happens if you don't do this. If you don't have any intellectual property provisions in place, there are a couple of provisions that, or a couple of generalities that we can make about what will happen. If you've got an employee that was not hired specifically for the purpose of inventing something, for instance, in the patent context, the employee typically owns anything that's invented during the course of the employment. And the Supreme Court has upheld this repeatedly, that when an invention is made, if it immediately vests in the inventor, no matter what. And then by operation of contract, it is given to the employer, depending on the circumstances. This only applies as a generality if they're not hired specifically for the purpose of inventing something. So under operation of certain kinds of state law, if you are employed to invent, a patent will vest in the employer, but in all other circumstances, the employee typically owns it. So this is something to be aware of. In the event that does happen, in the patent context, the employer does get a shop right, but that is certainly not something that I would want to rely on. And that's basically that even if in that event, the company gets a non-exclusive royalty fee, non-transferable license to use it, to make and use it. Here's another generalization. An employee that is hired to invent will likely be obligated to assign the IP rights. So that's the flip side of the first coin. But this is certainly not a guarantee, and there are all sorts of reasons and cases that have happened that have allowed employees to invent something and walk away with it or license it to other folks. So what do? You get an assignment agreement. When you have an employee that has invented something, it is, as a normal part of your business, you should have them execute assignment agreements that assign all right and title in that invention or creation of whatever sort to you, so that you are the owner and then you can take over any enforcement of that intellectual property right. These can often be included in an employment agreement, although it's important to note that we have a lot of independent contractor situations where this also is important. And you may hire a designer or an inventor or some other content creator to work on a project for you. And if you don't have it in contracts that what they create for you, it belongs to you, they're likely going to be able to walk away with it. So this happens a lot in sort of a software context where software designers, engineers try not to get bogged down into agreements, and they want to create you a web page, or they want to create some other piece of software for you, and then they want to walk away and sell their services to someone else and recycle a lot of the content that they've used before. They've got their toolbox of things. So this is a negotiable point when dealing with a contractor of that sort, but it's something you need to be mindful of, because down the road, if you want to go after someone for copyright infringement, for instance, you may not have the right to do that if your contractor has held it. Go ahead.
So I employ interior designers, and we're designing a furniture line. And so it's collaborative, so we're all sitting there tweaking the design. So what should I do? Because my employee could take that design and market it herself.
Sure.
If she left my company.
Yeah.
Okay, so the question is, one of the ladies in this room owns or works at a design firm, and so she collaborates with her employees on the design of furniture. And so she's wondering, what can she do to prevent one of her employees that is collaborating with her on the designs from taking a design and using it with another business or employer, or setting up shop across the street and using those designs?
That's a really good question. And it's fact specific. I mean, it's very specific to your situation. I would say that in your field, banking on one of the traditional areas of intellectual property protection is not a sure thing. I mean, it doesn't nicely fit into patent or trademark. And copyright's a bit dicey about that as well. So this is what an older attorney I work with would call a belt and suspenders thing, where you can try and wrap it up with one thing, but also I would always try to use contractual means, which Kelsey's going to talk about toward the end of it, as a way to sort of prevent competition, that design from walking out the door. I mean, what you can do about a third-party competitor is going to be really fact-specific about exactly what you're creating, but in terms of your individual employees or collaborators, I think contract is probably the strongest route.
And so I'll try to touch on that here later in the presentation. And so there's options, a lot of what Matt and I will touch on, that we can do to try to protect those issues as much as possible, but they're not always bulletproof. And a lot of times the employer's goal in terms of, do we want to just deter an employee from leaving altogether and kind of threaten what could happen if they do it? Sometimes that's some clients' objectives. Other times it's, we don't want that information to get out, and we want to be reasonable from the get-go, and we want our contracts to be reasonable. And so, what the client's goal is something that we try to find out right from the start, so that we can draft those agreements to foster that goal. And so I'll come back to that later in the presentation.
So this really ties into exactly what we're talking about. What can an IP assignment agreement cover? Plus know-how or any sort of other proprietary information that you want to be covering with an employee with that kind of agreement, and it is the primary mechanism for protecting patent rights and copyright. So that kind of relates to what I was saying earlier about belt and suspenders to some extent. You apply for it, you can go get it for patents and copyrights, but you need to have an assignment agreement in place or some other obligation to assign to you in order to have an undivided interest in it and be able to actually prosecute it yourself. So it gets you off the ground. Yeah, and so you can use it in the others as well, but it's particularly when you're dealing with patents and copyrights, be very mindful of the agreements that are in place with the creators coming to you. This is based on a fairly recent Supreme Court case, but the upshot is avoid an agreement to agree to do something. You don't want to sort of do a handshake and say this is what we're going to do, and we'll get it memorialized later. You want to have the agreement in place up front before you get started with things. And the actual language agreement to agree is a reminder that there was a case in which there were a patent case in which there was a disagreement about individual language inside an assignment agreement mattered, and so it's important to have someone, not just have a napkin on the back of it, or write something on the back of a napkin, but actually have the proper magic words or the appropriate assignment language in place when you're agreeing to an assignment. They can be broad, so take advantage of it. Let's move on a little faster.
Sure.
Establish procedures for timely disclosure of inventions and other protectable intangibles. So these are related, but if you're in a business where doing research and development, if you're collaborating a lot, you need to have standard practices. You need to adopt standard practices inside the organization that say, okay, someone's got an idea. What do they do with it? Because oftentimes, if you don't, in the case where you don't have those kinds of procedures and sort of culture in place, folks come up with things all the time, and you're A, at risk of losing them, and B, you may not even be aware that they've happened. Someone may have figured out a new way of doing something in an industrial process, and you may not have a system for, one, securing it, two, disseminating it amongst other employees that may want to know about something an improvement that's been made. So it's important to sort of, for a variety of very practical reasons, it's important to have procedures in place where people are thinking, should this be protected? Should this be disclosed to management, and a decision can be made about exactly how to go about protecting it at the entity level. So that's the real takeaway message. I sort of stepped on my next slide here, but stay informed of your business's innovations. Be aware of what your employees are doing, and then create an obligation of disclosure in the employment contract. It's actually possible to sort of write that into your employee handbooks and the other materials that your employees receive, and then provide them with sort of disclosure, what we would call disclosure forms. So they actually record that they've come up with a new idea or a new process or a new creation, and those are given to a point person, and then run up the chain to see what you want to do with them. Again, this is I've got too many slides on the same topic here. Create a contractual obligation with your employees. So a standard operating procedure is helpful in establishing legally relevant requirements, but contractual obligations are stronger. I mean, it's always a contract issue.
I'm gonna jump in here because Matt said pay attention to what your employees are doing. It's also important to update the documents that you use, because a startup company may grow and just take off and become a very large company. And so you might have job descriptions in place at one time, and you might have an employee that stays with you for 20 years. And so that person's access to your confidential information may evolve and may change. And so sometimes we see businesses and employers get in trouble when they don't update their documents, because when we're trying to enforce those contracts, the more current they are in terms of how much know-how that individual has is important. And so, updating your employment policies or updating any confidentiality agreements that you have with employees, so that if your business evolves, we can make sure that the confidential information that you want to protect is in those agreements and it's specific and we have it covered. And so just kind of docketing that on an annual basis to kind of reflect, where's our business at now, is a really good best practice.
That's exactly right. So the third point that I wanted to get to, because keep moving along here, is fostering innovation through incentivization. So in a kind of part and parcel with establishing procedures for the timely disclosure, you can foster a culture inside an organization that sort of incentivizes actually making those kinds of disclosures and producing protectable ideas. Some of the, Motorola and IBM have both been huge success stories with this. They have always incentivized their employees for bringing patentable ideas forward. They actually get awards for it, and then monetary bonuses. I think it's important to note that the patent system, for example, is built on the theory of incentives. The entire idea behind protectable intellectual property from the time of the writing of the Constitution was that they understood that if you could protect intellectual property, that providing protection for intellectual property incentivized people to create things. And I think that trickles down to inside an organization as well. So if you say, inventors are rewarded in some way for coming up with inventions, the amount of monetization for the organization is hard to calculate compared to what you might be doing in terms of bonuses. Yeah, that's really covers exactly what I wanted to say about that. So the next issue, and this is where we sort of transition over to Kelsey, is talk about non-disclosure, non-solicitation agreements that can protect your IP. So you want to take it from here?
I do.
All right.
So along the lines of kind of the culture associated with, how do we protect our business? In this, world we live in now where the unemployment rate is at an all-time low, it makes it very difficult because a lot of employees are looking for maybe the next best job. And so employers and businesses are faced with, what do we do when our employees leave? And what do we do when we want to look at another business to try to bring talent to our company? Of course, the best approach is to evaluate, who are those employees within your company that can do harm to your business, that, have a lot of your confidential information, and if they do set up shop across the street, who are those employees? And then making sure that we have agreements in place for them. So we're going to talk about 3 different types of agreements: non-disclosure agreements, non-solicitation agreements, and non-compete agreements. And so I'll kind of give you some background about how businesses can use these 3 different agreements and some of the issues that arise when we try to enforce them. And full disclosure, I've been on all sides of these contracts. I've been retained by businesses to draft them. I've been retained by businesses to enforce them or to get around them. And so I've seen it from all sides. That's why, your goals and your objectives matter. As we discussed with the unemployment rate being an all-time low, another best practice that you guys can implement is when you're onboarding employees or when you're interviewing individuals, you may want to inquire about whether they are subject to a non-compete or a non-disclosure agreement or a non-solicitation agreement. Because I have also defended employers and companies when they've been sued for tortious interference with a business contract or a business relationship. And so that's arose when an employee tried to poach, a high-valued employee, and the employer knew that there was the non-compete agreement in place. And it doesn't mean that we can't, defend against a claim like that, because the agreement may be unreasonable and unenforceable, but it may be an issue that you might want to be aware of in terms of onboarding your employees. So let's start with non-disclosure agreements. So non-disclosure agreements are when you ask your employees not to reveal your confidential information. So you can have this in place, and as Matt touched on earlier, this is one of the what we call restricted covenants, when it's the things not to do that we're trying to prevent the employee to not do certain things. Those are called restrictive covenants. And for this particular restrictive covenant, you don't need a time limitation on it. So Matt mentioned the Coca-Cola recipe. So those, employees that know that Coca-Cola recipe, they probably have a non-disclosure agreement that prevents them, throughout the duration of their lives from disclosing that secret recipe. And so that's okay. What's not okay is sometimes businesses and employers think, well, you can't talk about my business at all. And I can control what you say and when you say it, and if you say it on social media. And so that becomes problematic because, of course, in my world of employment, there's a lot of government agencies that care what some of your employees have to say in regard to OSHA and safety, harassment and discrimination, the Department of Labor in terms of employees talking about their wages and their compensation and that sort of thing. So for non-disclosure agreements, there's a couple of different things we need to be mindful of. First of all, how do you define confidentiality? That should be in your employee handbook. You should have a confidentiality provision in there. But we also need to make sure that we define it, and we define it in a way that's enforceable so that it's not overbroad, because there have been issues where different governmental agencies say, hey, employer, you're overstepping your bounds. You're trying to prevent, a whistleblower, somebody that observed fraud, from reporting it, and you can't do that. So Of course, in the employee handbook, we want to define confidentiality, and then in the non-disclosure agreement, we want to do that as well. So here's the trick. We want to define confidentiality, and we want to define what it is you're truly concerned about, but we also want to be broad enough to protect your business as it grows. And so it's a little bit of a dance in terms of, how we define it, and that varies depending on the business. So to enforce non-disclosure agreements, courts use a three-pronged test. Number one, it must be reasonably necessary to protect the employer's business. Number two, it cannot unreasonably restrict the employee's rights, and that's where we talked about, harassment, discrimination, OSHA violations. And number three, it cannot prejudice the public's interest. So the employer has the burden when trying to enforce any of these restrictive covenants, and this one, if it's drafted well, is, in my opinion, the easiest one to enforce, because oftentimes it's the less detrimental to your former employee. All right. So let's move on here and talk about non-solicitation agreements.
I'd like to add one more thing
Sure.
about non-disclosure agreements while we're here. One of the things that also need to be mindful of about non-disclosure agreements is that it does not have to only be used in the employee context. You can also use it with independent contractors or other parties that you may be seeking to have a collaborative relationship with, and a business partner, a joint venture, anything like that. You can use an NDA to protect yourself in those sorts of circumstances. There are many I often see situations where two different businesses want to sit down with each other, and they'll mutually agree to non-disclosure of one another's ideas. And then in the event that something pops up later on, and you sat down, you shared your ideas, nothing comes of it, and then later they start making your widget, you can go after them under contractual means, which is much, much easier than going after them under an intellectual property theory alone. So patent infringement is extraordinarily expensive, but suing for a breach of contract is a much easier thing to go after someone for.
Absolutely. And you can also, when you establish business relationships with others and you want non-disclosure agreements with that business, you can also have a clause in that contract that you expect them to have non-disclosure agreements with their employees, so that you don't partner with some business and then that employee takes a photo of some machine in your business and then posts it on social media later on. You can show that you took steps to protect that information, and that's something that you can ask for with your business partners. All right, so non-solicitation agreements. This is narrower than non-competes. So this is when you don't want a former employee to be able to contact your clients or your customers after they are, while they're current employees, to set up a competing business or afterwards. And so you can have this type of restrictive covenant to help protect against that. So similar to the non-disclosure agreements, the courts use the same three-pronged test, and it's really all about reasonableness. And that makes it very difficult and very fact-specific for the employer, because we need to defend, why do we need a non-solicitation agreement and the duration of the non-solicitation agreement. So it will come down to the scope of the agreement and the geographic scope and the time parameters associated with this. And then, of course, it's the employer's burden to argue that those parameters are reasonable and necessary. On several occasions, the Iowa Supreme Court has upheld 2-year non-solicitation agreements as reasonable. Much longer can become an issue because some of the former employees may argue, that's a restraint on my trade and on my ability to earn a living and that sort of thing. And so, again, the more we can justify why the restriction is necessary and appropriate, the better off we will be having longer non-solicitation agreements. So, it's better to have the non-solicitation agreement in place rather than to have an issue arise where an employee starts to do this after the fact, because you'll have less ability to try to protect your business. So an example of this that was a case that rose to the Iowa Supreme Court had it involved a pest exterminator who sent a customer a letter saying he left his employer and he's in a competing business and probably, lowered his rate and was hoping just to kind of take the client base. And so this employer had the right contract in place to be able to protect itself. And so this is an example where the Iowa Supreme Court enforced the non-solicitation agreement. So now let's talk about non-competes. So non-competes can be very valuable for your business, but you have to keep in mind that just because you have one doesn't always mean it is enforceable. So non-compete agreements are clauses in employment contracts that prohibit the employee from competing against the company and from starting their own business. So sometimes non-solicitation agreements may be okay, or you might agree to let an employee work for a competitor, but you just don't want that individual to take any of your customers and clients. And so that's the difference between the non-solicitation and the non-compete. The non-compete is, you do not want them competing against your business in any way. And so it's broader than the non-solicitation. So again, the test is reasonableness, which depends on the facts. And so courts look at the scope, the geographical limitations, and the time limitations. So by scope, it's, what is the business that this particular employee is in, and what is it that this particular employee does? Because if you have a non-compete agreement, it affects that individual's ability to earn a living. And so courts, are very... they scrutinize these agreements to make sure that there's other jobs or other occupations that the individual can do, because you can't just prevent them from working entirely. So when I draft these agreements, I try to drill down with my clients to figure out, what is it you're most concerned about, and then even provide examples of other jobs or occupations that this individual can do that's not in violation of the non-compete agreement. And if we set that out at the outset, I find that helps us argue the reasonableness. The two other criterias are the geographic scope. Are we concerned about just Des Moines? Are we concerned about all of Iowa? How big is the jurisdiction or the geographical parameters that we're worried about? Being able to enforce that depends on your business and how your business operates and the harm that can result to your business. And then, of course, the time. Are we concerned about 6 months? Are we concerned about 2 years? We can put in your employment contract whatever time you want, provided the employee will agree to it and sign it. But just because we put in there 5 years doesn't necessarily mean that it is enforceable. I'm going to kind of jump along here. So here's some examples of the geography and how it depends on the circumstances. A 10-mile radius was reasonable for a pest exterminator. For a livestock veterinarian, a 250-mile non-compete radius was reasonable. And again, courts will reduce the geographic and time limitations based on what they think is reasonable. And so this is called the blue pencil doctrine, and that's what we have in Iowa. And what that means is the court may say, well, you wanted 5 years and you wanted 250 miles, and I don't think that's reasonable. I'm going to make it 6 months, and I'm going to make it 25 miles from your business. So that's called the blue pencil doctrine. Currently, Iowa has that. I'm going to jump along here. Now, there's been a trend across our country and primarily in some states about non-compete agreements and them being used for employees that maybe shouldn't be subject to a non-compete. So for some fast food chains and for Jimmy John's, where we typically may have a variety of employees that are in the lower income bracket, they have been subjected to non-competes, and so there's been a lot of legislators and lobbyists and politicians that have been very concerned about that because that prevents them from trying to better their life and earn a better quality of living. And so there's been a lot of lawsuits over this, and Jimmy John's is a famous one where they agreed to pay $100,000 to the Illinois Attorney General. In this case, the Illinois Attorney General filed a lawsuit and sought a variety of different remedies. One of them is called a declaratory judgment action, which is basically saying, court, we want you to rule that their non-compete agreements with, this classification of employees is unenforceable and it's invalid. And then they also took it a step further and sought damages. And one of their bases was the consumer fraud statute in Illinois that other states have, to try to say that, Jimmy John's really didn't have a legitimate interest here in protecting the minimum wage worker from not, working at another fast food, restaurant in the same market, and so it was detrimental and harmful. So other states across the country, Iowa's not one of them, have implemented laws to try to curtail non-compete agreements and when they can be used. Some of the legislation that's been proposed in other states is to only have this be an option when you're onboarding employees so that the employee will know up front if they're going to be subject to any restrictive covenants. That's not required in Iowa. Employees do have to have what's called consideration. They have to receive some value for giving up their rights to, go compete or disclose certain information. But you can enter into these agreements with your current employees, and ongoing employment is sufficient. But when we are trying to argue reasonableness and trying to enforce those agreements, we'll have a better time doing so if we can explain that this particular employee truly does have access to the confidential information and truly can't harm your company, and we can point to tangible value that they received in return, whether that's lucrative compensation or, certain things like that. And so the more we can point to that, the better off we'll be in trying to enforce it. So in Jimmy John's non-compete, they tried to prohibit employees from working for a competitor within 3 miles of the store for 2 years. And the competitor was defined as any company where 10% of its value is from sandwiches. And again, this resulted in a settlement for $100,000. We talked about the blue pencil doctrine. Another area that lobbyists and some politicians are trying to have statutes on is called the red pencil doctrine. And it's basically when employers overreach and try to, just have these strong deterrent restrictive covenant contracts and say, you can't work in our whole state for 5 years and make it really burdensome for an employee. They're trying to say that courts, when that happens, don't enforce the contract at all. So it kind of encourages the employer to want to have agreements in place that are indeed reasonable. Iowa has not gone to that extreme, but of course, sometimes employers just want the deterrent effect and we can rely on that blue pencil doctrine, but other times we want to be able to argue that the non-compete agreement is reasonable, and so there might be a motive to not have those be overly broad. So here's an example of some of the states that have statutes and have tried to make it more difficult for employers to have overly broad restrictive covenants. Illinois, Massachusetts, New York are a few examples. And again, Iowa is not yet one of them. And they try to focus on the low-wage earners and jobs that affect the public. So now let's move on to the remedies for a non-compete. So when you have an employee that leaves your company that is subject to one of these agreements, what do you do next? Well, when the employment relationship ends, you should have a conversation with them and remind them of these contracts and document that you reminded them of this. So that way, if you have to call me or another attorney 6 months later, we can show we reminded them and they knew that they were subject to these agreements, and they can't say, I forgot, sort of thing. And then we can send them a letter reminding them, we have these agreements in place and we're going to enforce them. A couple of different options we have that we suggest you put into your restrictive covenants and actually have as clauses in your contract if you want them are temporary or permanent injunctions. So an injunction is saying, court, I need you to intervene and I need you to stop something. So it's not necessarily trying to get monetary damages, but more so this employee just left Coca-Cola and they know our recipe and they're going, to another company and they're going to take it. And so we would go to court and try to say, court, I need you to, stop this before it happens, or stop this individual from setting up his or her competing business because they're planning to do that. Injunctions are very high standards to meet. We have to show that there is indeed irreparable harm that's going to result if you want that sort of remedy. So how we draft the contract, we'll try to touch on that so that we can argue to a court that we can meet that standard. But that is difficult because courts will think, if you can just get monetary compensation for what happened, courts prefer to do that unless there really is a threat of irreparable harm. We can also seek damages. For example, with that pest exterminator case that we talked about earlier, where the former employee contacted the customers and clients, there's likely a loss of goodwill. It was probably embarrassing for that company to have clients know about it. Maybe some of the customers left to, pay less and have this other individual do the work. So we would have the burden to prove your damages, but that's another remedy we can seek. You can also seek what's called liquidated damages, and that is when the employer and the employee agree up front to the type of harm that might result if certain circumstances occur. And so that's where you would agree to the dollar threshold for a violation. And so that's an option that we can put into a contract. And then another one is, of course, attorney's fees. So if any of these restrictive covenants are violated, you can have a clause in there so that the employee agrees up front. If this agreement is violated, I agree that the prevailing party can recover attorney's fees. And so that can be a useful tool and a useful deterrent to try to protect your business. So here are some of the takeaways for non-compete agreements. Be specific. Tailor it to your business and your particular needs. Don't use a generic form because that will be harder to enforce. And think about, what are the limitations that you need for your business in terms of the appropriate restrictions for these 3 restrictive covenants and the scope of these covenants. And evaluate attorney's fees and, remind employees, preferably, when you onboard them, try to get these agreements in place. When they, leave your company, bring them up. And then also try to evaluate on an annual basis, or at least, every so often, what your employees are doing, because employees may stay with your company for a long time, and you might need to, re-enter or create new agreements depending on what know-how or information the individuals have acquired. So this is kind of a summary of the various options that you have available to protect your company. And how are we doing on time? Okay, so we have a few minutes for questions. We're happy to answer any questions you guys.
Things like that is kind of understood in the industry. Can you say that there's any understandings or laws that prevent disclosure, solicitation, and competing? Is that kind of like common knowledge, or do we really have to put it in writing? Can we go to court without having that in writing?
I will kind of let us both answer this question. From my world, I prefer to have it in writing because it shows, the steps the company took, and also if we have it in writing for, you might not need a non-compete agreement for every employee in your company. It's really meant to be those high-valued employees that really do have access to that information. So the agreement is the best way to do it. If you don't have the agreement, there might be some trade secrets that can touch upon in Matt's world that we can use to try to protect your company, but we're not going to be, as efficient or have as much zealous advocacy to protect your business as we would otherwise like.
Right, no, I think that's right. I think anytime you can get something in an agreement, it's always preferable. It's never, you don't want to rely on something happening automatically. You know, you need to have written agreement.
And along the lines of the company culture that we touched on earlier, we really need to think about, you know, what access are we giving to employees at, you know, the whole array of your hierarchy within your business, and then also use technology wisely. If there's certain information that you need to protect, you know, make sure we're only giving that information to certain employees and that we have adequate precautions in place to protect that. And so that is not only with the agreements, but also with, you know, other ways within the business that we can do that, you know, from a non-legal standpoint as well.
Right, like a database, for instance. I mean, it extends all the way down. If you may have valuable intellectual property simply in the existence of a database. And if that's the case, and a lot of people don't even consider that to be so, but if that's the case, you may not want to allow everyone in your organization to have access to that database that they can simply put on a jump drive or email themselves.
And another example that I've seen through litigating these restrictive covenants is when employers have them with just anybody and everybody within their business, what ends up happening is the employers don't enforce them all the time. So with the Jimmy John's example, when you have you know, a low-income worker that wants to go leave to be a manager at a fast food restaurant, you might not enforce it. Well, in the world of employment, the employer or the business's pattern and practice can potentially be relevant to the issue that is being litigated. And so that's, again, another example. We want to think about, you know, who are we giving access to this confidential information, and then having the appropriate precautions in place. So one of the things I do is we might have non-disclosure or confidentiality agreements with a variety of employees, but then only your really valuable employees would be subject to the non-compete. And so that's one way to try to make a distinction between those employees that can really affect your business. Yes?
I noticed you talked about a clause for attorney costs, recovering them. Do you have to provide the same likewise compensation if the employee prevails?
So it all depends on how you negotiate the contract and then how the contract reads. And so that's an example of, it depends on how the contract is drafted. And if you want it to only be recoverable for the business, if we draft the contract that way and the employee agrees to it, then, you know, then it's possible only you will get the benefit of that bargain. But it depends, you know, on how these terms are negotiated. And it also affects reasonableness because, like the courts here with the Jimmy John's example, the sophistication of the parties and their knowledge, you know, can be taken into consideration in terms of what is reasonable. So if somebody is, you know, if both parties, the business and the employee, have an attorney and they're negotiating on it, then I'll use that as a factor to say this is reasonable. They knew what they were doing and they agreed to it. You know, the flip side is if you have a really strong contract and you have liquidated damages in there and attorney's fees, and you make it just almost impossible for a low-wage earner to go look for a better job, then it's going to look like you're just trying to, you know, restrict them and you're not really trying to protect your business.
Right. The thing to keep me mindful of, the shortest version of what to be mindful of is that negotiating these things and thinking about these things up front for your onboarding people, when you're setting out how your company is going to operate, attorneys are less, you know, your legal costs are going to be less expensive at the front end than they are at the back end in almost every circumstance.
Yes.
Like insurance.
Absolutely, yes.
I'm not sure if you have an answer for this question, but as an employee, are things like non-competes negotiable? If I provide a company and they put a form for me I didn't like, can I try to negotiate it, or my chance of getting a job there are something?
It depends. It depends on the company, and that's why there's more and more laws, you know, trying to be written in a variety of states, is because some individuals feel like an employee doesn't have the same bargaining power that an employer does, because, you know, the argument is in tough economic times, you can put any restrictive covenant in front of an individual and they're going to sign it because they don't have another choice. So that's why there's an effort being made to try to curtail these. So, yes, an employee can negotiate with any employer, but some employers may be open to negotiations and some employers may not be. So it just depends. And then, after an employee leaves the company, negotiations can continue because, sometimes we'll negotiate the parameters of a non-compete to avoid a lawsuit. And so negotiations can happen at any time, but to negotiate, both parties have to be willing to do so, the employer and the former employee or prospective employee.
As a general rule of thumb, the higher up the sophistication and monetary scale of an employee goes, the more valid these kinds of covenants are. And that's why Jimmy John's got in trouble, right? I mean, at the end of the day, it's because courts look at the balance of the equities and say, if you're a dentist, that's one thing. If you make sandwiches, that's a different thing.
Absolutely.
All right, guys, so let's give them a round of applause for donating their time to be here today. They'll stick around if you have a couple other questions maybe you wanted to ask offline as well. They'll hang around for a little bit. I do want to mention there's surveys on your table. If you're watching it online, you'll get an electronic survey. If you can complete those and give us other ideas for what you'd like more information on for next top 5 sessions, that would be great. We're planning 2019. And then just a couple, I shouldn't even say a couple, there's a bunch of small business stuff coming up to continue your education. So if you know somebody that is looking to start a business and exploring the different kinds of capital they might need, loan versus microloan, state programs, we have an event on August 2nd. It is limited to 20 people because there's a ton of information to get through in a half day. That is up, registration is open. Our Female Entrepreneurship Series is on August 3rd. Our first Friday session will be out at the Iowa Women's Center. It is August 3rd. It is Carrie Rush. Will be sharing her journey. On August 22nd, we'll be back in here, and we're talking technology, top 5 apps that you should have for your business. We'll be in here. September 11th is a brand new event. It's called Creating a New Revenue Stream for Your Business. It will focus on e-commerce, whether you are a retail storefront or even a service business, how everybody's moving online for appointments, for purchasing, all of that. We will actually have Google coming in to teach us a session on how to measure your online success. And we have 3 local speakers talking on how they've sold just on Instagram all the way up to having multiple retail stores and their online store. And then a lady actually in town will be speaking on how she's selling in over 1,000 boutiques online and working with Zulily. So all different success stories right here in your backyard and how they did it. And then November 9th, there's a flyer on your table. That is our Small Business Success Summit. Davis Brown is actually one of our sponsors for that event. We're expecting over 300 people to show up at that event this year. Great content, 3 great keynotes, and 18 breakout sessions. So get ready. There's a lot coming this fall. Hopefully you can join us. And thanks for coming today, guys.
Thank you.